Hi, I'm going to be arguing on behalf of the prosecution to the Supreme Court that the Court of Appeal wrongly decided the case of Evans. Evans was a footballer who was accused of raping the intoxicated complainant in a hotel room under his name. Whilst his co-defendant was acquitted, he was convicted. However, after fresh third-party sexual history evidence came to light, Evans was also subsequently acquitted, and I argue that this third-party evidence should not have been admitted. My first submission is that that the court misinterpreted their application of Section 41 of the Youth Justice and Criminal Evidence Act, and the evidence in question did not fit through any of the subsection 3 gateways. My second submission is that it should have been excluded for its low probative value and high prejudicial effect under Section 42(1)(b, and because its purpose is to impugn the credibility of the complainant under Section 41(4). Lastly, I will argue that this decision was contrary to parliamentary intention and that the court contradicted itself in invoking Section 3 of the Human Rights Act at the end of the case. My first submission is that the court misinterpreted their application of Section 41 in applying the plain and regular meaning of the Act. There were two possible relevant gateways here. Firstly, the similarity gateway under subsection 3ci, and secondly, the not an issue of consent gateway under subsection 3a. The first gateway states that the evidence may be adduced if it's an issue of consent and the sexual behaviour of the complainant to which the evidence relates is so similar to their sexual behaviour in the events of the case that the similarity cannot reasonably be explained as a coincidence. In the Evans judgment, the Court of Appeal relied on Lord Clyde's comments in the RVA judgment at paragraph 135 that the conduct need not be rare or bizarre and not so unremarkable as to reasonably be explained as a coincidence. But, as pointed out by McGlynn, the double negative of not so unremarkable means in fact that the conduct must be remarkable. This contradicts his earlier comments that it need not be rare or bizarre. Nevertheless, if we assume that this was just a literary mistake on his part, the court contended that the similarities in question, namely that of being intoxicated and directing the defendant into sexual positions and using specific words of encouragement, were sufficiently similar to be unexplainable by coincidence. However, as per Government Minister Lord Williams, the subsection was not designed to cover evidence of a general approach towards consensual sex, such as a predilection for one-night stands. Still less does it include the fact that the complainant previously had sex in a car before alleging that she was raped in one. Such behaviour falls within the usual range of behaviour that people display, and this casts doubt over the remarks that the conduct need not be rare or bizarre. Statistics from studies published online can enlighten us on the commonality of these supposedly sufficient similarities. 51% of respondents in Wales and 57% in the north of England said doggy style was their favourite sex position, whilst the search for fuck me harder wielded 1,259 results, with many more for harder and for doggy position on the popular porn site Pornhub. Thus, as Stark highlights, there's nothing particularly important about this evidence, and it would add very little to the proceedings. Still, if we were to say that intoxication stands as a similarity, the Court of Appeal failed to demonstrate an attentive and considerate approach in pursuit of accurate fact-finding. Fundamentally, the court failed to acknowledge the very simple fact that intoxication levels fall on a broad spectrum. R.V. Bree in 2007 provides us with a precedent regarding intoxication. If the complainant is incredibly drunk but remains capable of choosing on whether or not to have intercourse and agrees to do so, then this would not be rape. The Crown Prosecution Service declares, however, that a complainant does not need to be unconscious to lose this capacity to consent, and therefore there's a fine line between the two. Taking the evidence of Mr. Burrow and Mr. MacDonald, X was extremely drunk and sick, and therefore it's very possible that she was too drunk to consent or too outwardly drunk to establish the defendant's reasonable belief in her consent under 41(3)(a). Compare this to the absence of such details in the accounts of Mr. Owens and Mr. Hughes, and it becomes clear that it's not as simple as just admitting evidence because of a surface level similarity. Furthermore, Lord Clyde's comments were obiter and point towards behaviour between the complainant and the accused, not with third parties. R.V. White also clarifies that RVA is not authority for any wide reading of Section 41 by Section 3 of the Human Rights Act. It would at least require a very special case, which I argue this case is not. My second submission is that, even if the evidence did fit under one of the gateways, its low probative value and high prejudicial effect mean that it should have been excluded under Section 42(1)(b and also under Section 41(4), because it's reasonable to assume that its sole purpose is to attack the complainant's credibility. Trying to decipher what else the purpose could be for adducing this evidence, we fall short of ideas. Firstly, it cannot be used to establish X's consent because of the lack of distinctive similarities stated in my first submission, but also because consent is given new and afresh each time. As per Lady Hale in RVC, sexual relations are uniquely person and situation specific, and there's no generalised consent to sex. Secondly, it cannot be used to compound the defendant's reasonable belief in her consent, not only if she was outwardly too drunk, but also because the defendant should not be able to benefit from evidence whose existence he was unaware of at the time of the alleged event to contribute towards his own self-assessment of X's consent. Additionally, this third-party evidence was acquired through the hire of private investigators by Evans' family, and we're not sure what information was fed to these third parties before they made their statements. Therefore, it follows that the only possible reason left is to attack the complainant's moral credibility, and that it produces an unequal power dynamic between the parties involved, a view propagated by McColgan. Thus, Evans is handed an advantage over the proceedings on a silver platter, while shifting the burden onto X to prove her own virtue and chastity. As stated by Carol Smart, a woman faces a double burden of proof. Firstly, that she must have been unwilling to have the intercourse, and that secondly, she could not possibly have enjoyed it. If this proves difficult, as opined by Holly Baxter, X would be asking for it or in some other way culpable in her own rape. Accordingly, when society has shifted away from traditional stereotypes regarding the angel in the house ideal and the passivity of women in sex, and has developed a myriad of religious, cultural and personal manifestations of being female, liberated as a female, it feels wrong to warp the proceedings into essentially what is putting X on trial for being who she is, a woman who came into her own understanding of what it is to be sexually autonomous. It instead sends society 10 steps backwards to the days of fallen women who lost their place in society after having sex out of wedlock as their libido was denied and their purpose was seen as merely reproductive. Those women were wronged by society then, and I argue that the admittance of this evidence wrongs X now. My final submission is that the lack of clarity of the law in this area and the warnings following RVA mean that at any event this is exactly what the court should have avoided. Instead, the Court of Appeal should have signalled to Parliament that reform was needed to rectify the lack of clarity within this area. Any belief held by Birch that the measures following RVA were draconian and unjustifiably restricted is completely obliterated by the judgment in Evans, which not only opens a floodgates to third-party evidence, but risks a tsunami, as stated by McGlynn. The court should have instead taken a step back to reassess parliamentary intention, which could have never been to trudge through a complainant's entirely ordinary and commonplace but nevertheless deeply personal sex life. This stands completely against the principles of humane treatment and the protection of the innocent, and we were warned of this by Redmayne, who noted that although RVA was a necessary compromise, the law following it provided an unstable approach and moved towards greater admissibility of prior sexual history evidence. We mustn't ignore the impact that this would have on victims coming forward. It's also worth assessing previous case law. In R.V. White, the complainant's job as a prostitute was correctly deemed irrelevant to establishing consent. However, this took a turn in R.V. Hamadi, stating that the wider importance of RVA lies in the recognition that protecting complainants from indignity and humiliating questions must ultimately give way to a fair trial. This was echoed in Evans' judgment at paragraph 74, although wrongly. Comparing it to RVA, the Court of Appeal in Evans reached its conclusion via ordinary methods of interpretation. It didn't feel the need to read down the meaning of the statute or stretch the statutory language. So we must then ask why at the end of the Evans judgment there is a need for section 41 to give way to the requirements of a fair trial, as it seems this was unnecessary. The evidence was deemed similar enough as it stood to fit through the gateway. Thus, the fair trial point almost seems shoehorned into the judgment, just to justify the admittance of evidence. Sections 38 and Section 39 of the Youth Justice and Criminal Evidence Act state that D has fair trial rights to cross-examine witnesses, and in the event they cannot, for the judge to direct the jury not to draw adverse inferences. So I argue that instead the judge should have directed the jury not to draw adverse inferences, as the defendant's fair trial rights were not affected. Parliament should have instead required a demonstrable pattern of highly distinctive and unusual behaviour, as pointed out by McGlynn. This could have involved the filming of X in a situation involving multiple individuals, which would have matched the distinctive use of the level of distinctive similarity as the use of a climbing frame in the case of RVT. But as it stood, The evidence was irrelevant, unimportant, and overwhelmingly prejudiced X, a woman who felt so vulnerable that she came to the police despite knowing that she could not aid in her own account of the defence that took place, and or later in the defence of her own character due to her memory loss. Thank you.